So have you considered this question of nullity or divorce? If you have the choice, which one would you go for? If you can choose. Why? Do you want to share? Because money? Okay, you think it's money. What about, sorry, what's your name? Trump? Trump. Okay. Okay, Jim. And, sorry, what's your name? Laurie? And you mentioned, yes, I thought you mentioned, why? So what? Well, but then if you have a decree of nullity, people would know that you have endured a relationship that is like a marriage. But just that in law, if the marriage is void, then it's simply treated artificially in law that it never existed, but it did factually, right? It did kind of live their life together. It's all legalistic and technical. And in terms of the question, there's actually, from reading legislation, there is no difference in terms of financial relief, whether you have a decree of nullity or a decree of divorce. That's under the MPPO, which we will talk about later when we go into finance. Any other views? Just by, from what we have discussed today and how you understand a divorce, which do you think is more advantageous? There's no right or wrong. I just want to know. Yes, Laurie. Divorce is better? Oh, sorry. What's your name? Dorothy.
Because for novelty, I still need to pay extra money to prove everything before I get my marriage void. For divorce, I would just submit a petition and then get everything done, and I don't need to see that man anymore.
You will change your mind. Well, to give you a heads up, there are 3 parts in a divorce. There is the divorce itself, where you have a change of your legal status as to whether you're married or divorcee. But there are also the parts of children and finance. So petition for nullity is analogous to the divorce itself, the part 1 of the whole divorce. Usually in Hong Kong, a divorce is not defended. But it doesn't mean that you don't get to see your ex-husband anymore. Because even if you are acting reasonable, your husband might be very unreasonable and fight everything, including the divorce itself. We'll talk about that on Friday. Any other views? Why? Why? The Form 1. So you're worried that the public will find out that you were not a bachelor. Would that lead to a divorce upon discovery? Now that's what I'm talking about when I say sharing experience. 出賣朋友。Right. Sorry. I don't think so. Mistake is more about whether you think this is the guy I'm marrying, like the identity of that person, but then it turned out to be otherwise. So it's kind of like an attribute. Yeah. But well, if you really care, just get a divorce. You can always get a divorce as long as you have a valid marriage, even if you can't prove nullity. Any other views? This is an open question. There's no right or wrong. Okay. To me, the answer is simply technicality. As a lawyer, because for nullity, you really have to prove nullity in order to get a decree of nullity. But for a divorce, you can always get a divorce. If you want to get a divorce, you just separate for a certain period of time, and then you get a divorce. But for nullity, you have to satisfy those grounds, one of those grounds. If you can't find a ground that we just talked about, then it's simply not available to you. So, for a voidable marriage, if you want a petition for nullity for a voidable marriage, it's kind of like getting a divorce, in a sense that you have the right to petition for nullity or not. Do you remember? It's because there are some factors that give rise to a voidable marriage. If you seek a decree, then at the grant of the decree being absolute, then the marriage is being declared as null and void. So it's kind of similar to a decree of divorce, where at the declaration, then the marriage, you're divorced. The marriage ends. It's kind of the same. It's a right. Whereas for a void marriage, of course, as I said to Dorothy, no, I think Laurie. Factually, you have endured a relationship. You spent your lives together. You had a relationship together. Factually, the marriage existed between you. Your relationship existed, but void is just how the law sees it in its strict technical and legalistic sense. It is treated as it never existed, but it did. There are arguments. I think that's kind of similar to, sorry, what's her name? Simon. Similar to what Simon said. Well, what he shared, if you couldn't hear, was that a friend of his, when when she was about to get married, she found out that her fiancé was divorced when they were about to get married, and she only discovered it when they were about to get married, when you do the Form 1, when you file the notice of intention to get married. For traditionalists, in traditional Chinese, very old school kind of situation, some people, I don't understand it myself, but some people still see a divorce as a failure in your life. I see a lot of you nodding. Maybe I live in a different space. Some people see it, or especially their parents, if you're old money, very traditional family, the parents might see the children's divorce as a shame to the family. And also, there might be some comebacks if your family is, the famous families in Hong Kong. You don't want people to know that there's a divorce in your family, because that affects your share values as well in your company. But then, as I said, nullity is only available when you can find a ground for nullity. For divorce, you can just get separated, and it's really easy to satisfy the requirement of separation for divorce. So if you can find a ground for nullity, you can try. But even if you fail to prove nullity, you can still go to divorce, as long as it is a valid marriage. There is also some concern about the disclosure of private information in a nullity, because for voidable, you can have a ground saying that your partner has refused to have sex with you throughout your marriage. Or maybe even worse, your partner is incapable. You would have to disclose the information on the court documents. Of course, these documents, as within matrimonial proceedings, they are private and confidential. But still, you will have to bring it to the court. Now, so if this fact exists, you have to decide whether you want to bring it to the table, whether you want to tell your lawyers, whether you want to tell the court and defend it in court. Some people really care about these private information. But then, for marriage, there are grounds such as adultery and unreasonable behavior, which are usually relied on when a party to a marriage is in an affair. There are all kinds of ugly allegations in those petitions as well. Imagine when you petition for divorce, or imagine if you break up with your boyfriend or girlfriend, you say all kinds of dirty, ugly things to the other party just to hurt them because you're angry and you're frustrated. It happens in a divorce as well, and it's maximized in the petition. We'll talk about that on Friday. So in reality, there's no difference in terms of the degree of disclosure of information. In here, of course, you have to talk about no sexual intercourse, but you're also free to do that in a petition, or your partner is free to do that in their petition for divorce from you. Can't control it. I can share this with you. The first case I've done since my practice, the petition was from 2015, 6 years ago, 6.5 already, I think. It's still on appeal, it's still ongoing. I was not involved in the main suit, the divorce itself. But apparently, what the wife has petitioned is included in the petition for divorce. I represent the husband, the respondent. The wife, part of the allegation is saying that the husband has refused to have sex with her. And the client that we had is also very hot-tempered. And he basically, in front of the instructing solicitor, is a female solicitor, and when he heard from the solicitor what the wife has said in her petition, saying that the husband refused to have sex with her, the husband told us a very interesting story. He wanted to defend the divorce by saying that, no, I cooperated with her request to have sex. For instance, once he was already get dressed and he was about to head to work, and the wife demanded sex from him. And the wife stripped him at the entrance to their home, and they had sex. he wanted to defend that main suit on this fact. So you see, the facts on sexual stuff can get very detailed, it can be contested. If he chose to defend that divorce, everything will be set in open court. So you can all go to see that. You can all hear that evidence in open court. Of course, we didn't advise him to do that because it really is unnecessary. So there is no competition between nullity or divorce in terms of how much information is to be disclosed, how much private information is to be disclosed. It can get as ugly or even uglier with a petition for divorce. So I think the main concern is whether you can successfully prove nullity, either by saying that the marriage is void or voidable. Okay. Separation and maintenance orders. That's for married couples who are still married, but they are separated. They're not getting a divorce yet. The possible scenario could be that you're unhappy with each other, say, but the wife, for instance, wants to give a chance to the husband. She's hoping to save the marriage. The husband is hoping to save the marriage. Or you can have this arrangement when you are married for less than 1 year. Because in Hong Kong, if you're married for less than a year, you can't get a divorce. That's for the reason that our law encourages reconciliation if it is possible. And that's why there's a 1-year bar for divorce. And in the meantime, you can have this arrangement. Now, but in reality, from a practical point of view, if you are, you can free to separate from each other's and you can have private arrangements as to maintenance during your separation. But if you're making a move to make a formal application to the court, then the issue, your conflicts are really high. It is already at a very high stake. And eventually, it is very, very likely that it will lead to a divorce. And it's just, what happens before you get a divorce, actually. So why would you get a separation and maintenance orders? Usually during the period when you're separated, you just fight and fight and fight and fight. And before you realize, you already passed 1 year into your marriage. And then you might be able to petition for divorce based on separation. So I really don't see in what circumstances. First of all, I haven't encountered a case like this in my life. I haven't heard from a practitioner who has done this kind of application in their practice either. It is really a rare creature. So I'm afraid for this part, I can only tell you, go through the legislation with you. I can't really share my real life experience with this. If there's any real life experience these days with an SMO. So I'm just giving you an overview. Under Section 5 of the Separation and Maintenance Orders Ordinance, a separation and maintenance order can include that a party is not bound to cohabit with the other, so that's a non-cohabitation order, or it can include an order regarding the custody of the children of the marriage to be given to one of the parties during the separation. The order can include maintenance in a lump sum format or periodical payments, or both, to the other party. It can be a maintenance order or education order for, maintenance order in lump sum or periodical payments for the children involved, and it can include an order for the payment of costs. To get, also the jurisdictions for granting these orders lies in the district court, as indicated in the ordinance. So if you want to make an application for a SMO, you start the application at the district court level. It doesn't provide for an application starting at the court of first instance at the high court level. It is possible by way of transfer, but primarily the application is heard at the district court. Now, in order to get one or more of these separation and maintenance orders, there are 8 grounds for you to try and get these orders. So A, when a married person has been convicted summarily of an assault upon the other party to the marriage, which in the opinion of the convicting magistrate is of an aggravated character. So if a party has been convicted of a criminal offense at the lower level of court at the magistracy, and then in the opinion of that magistrate, the judge, it is of an aggravated nature. So it's serious enough. Similarly, for B, if the person has been convicted, whether on indictment or summarily, of an assault upon the other party to the marriage and sentenced to pay a fine of more than 500 or to a term of imprisonment exceeding 2 months. So this is even more serious, I think, because of the wording of indictment. Have you done any kind of criminal law yet? So, well, basically, what I mean is that in A, you will see the wording of convicted summarily. Usually, if the proceeding is done summarily, it means the offense is relatively not that serious. That's why, that's what summarily indicates. But if in B, you see the word of indictment, indictment is usually when you have a case at the high court level. That's when you will have an indictment. It's way more serious. Or if it's summarily, but then you're sentenced to imprisonment of over 2 years, that's equally serious. Well, that's not as serious as indictment, but it's more serious than A. So C is where a married person has deserted the other party to the marriage, and D, when a party has been guilty of persistent cruelty to the other party to the marriage, or the children of that party. Now you don't, if you want to get an order, you only need to plead 1 ground. 1 ground is sufficient, but of course, you can run multiple allegations on multiple grounds for the order in your application. It depends on what orders you want to get and what facts are available in your case. So E, you can get an order if a married person has failed to provide reasonable maintenance for the other party or for the children when the married person is legally liable to maintain. Or whom the married person is legally liable to maintain. F, where a person, while suffering from a sexual disease and knowing that he's suffering that sexual disease, that person has insisted on having sexual intercourse to the other party to the marriage. This is arguably, I think it's criminal assault. I think that's criminal. Arguably. G, if you have compelled your spouse to submit to prostitution. For ground G, it doesn't matter whether that wrongdoer realized that he's compelling his or her spouse to submit to prostitution. The issue is whether the court is of the opinion that the guilty conduct was likely to result or has resulted in the other party submitting to prostitution. So it doesn't matter whether you think you're compelling, but if the objective circumstances suggest that what you are doing would lead to the other party submit to a prostitution, then the wrongdoer is deemed to have compelled the spouse to submit to prostitution. So it's judged from an objective angle. It doesn't matter what the wrongdoer subjectively believes. Is it clear? Okay. For H, you can get such an order if a married person is a habitual drunkard or a drug addict. Habitual drunkard and drug addict are actually defined in the ordinance. They mean a person who is, by reason of habitual intemperate drinking of intoxicating liquor, or habitual taking or using, except with medical advice, of opium or any dangerous drugs, at times dangerous to himself, herself or others, or incapable of managing himself or herself and or his or her affairs. Again, if you read these grounds, if any of these actually happens in your divorce, will you stay in this marriage? Will you not get a divorce? In modern context, I really cannot imagine if any of these situations arise, then you would still consider giving a chance to the other party and ask for a separation maintenance orders. It is available, but if you look at it from a realistic glance, how can you endure this in a marriage? Another angle for you to think about the practicality behind a SMO. Any comments, questions? No. Now, for a non-cohabitation order, as I said, there are 5 types of orders. You can have more than one. It depends on the ground you plead and the alleged facts. A non-cohabitation order, it's basically to address the situation where there is presence of violence or assault conviction, such as in ground A and B. The considerations are whether such an order is necessary for the protection of the applicant, whether the case is more than a serious case, and whether there is a reasonable prospect of reconciliation. So the court would, on one hand, consider the seriousness of the case, but on the other hand, the possibility of reconciliation before an order is being made. It is a balancing exercise, and the court should not, through granting too draconian an order, to push the situation so far that it eliminates or eradicate any chance of reconciliation. It's a balancing exercise. So from the grounds, you have the slide. If there is persistent cruelty in the marriage, then it can give rise to a non-cohabitation order. Or if you have sexual disease and then you force the other party to have sex with you, that's also actually persistent cruelty, and I think it's also an assault. And also, if a party is compelling the other party to submit to prostitution, or for habitual drunkard or drug addict, these are all overlapping grounds, and they can be considered as, again, persistent cruelty, and it might lead to a non-cohabitation order, in my view. For custody order, there can be a order granting the legal custody of any children until such children attain the age of 18 years old. From the face of it, it is quite similar to a custody order that you would get following a divorce. And I don't see any further restrictions relating to this order. And you can see a maintenance order for the spouse. What it says here is that firstly, it can be a lump sum. The lump sum can be paid in one go, or it can be by installment. It can be in the format of periodical payments, or you can have both. In considering whether you will grant such a maintenance order to a spouse, whether in the format of lump sum or periodical payment, the court would look at the payer's means to pay, his ability to pay, and the means of the payee, the resources that are available to the party receiving the funds. The limit here is the requirement of reasonableness, as I have bolded and underscored here. So you also know that it is either a reasonable maintenance in going forward, or for the secondary part, which I didn't highlight. The bottom half, which I didn't highlight, it can be a lump sum for the purpose of enabling any liabilities or expenses reasonably incurred already before the order is being made. So if you want maintenance in going forward, it has to be reasonable. It can be a lump sum, or it can be periodical payments. But if it is for settling expenses that have been incurred in the past, there's also the requirement of reasonableness, and it is only for a lump sum order. You can only have a lump sum order for that. It makes sense, because when you have a debt, you can't have a periodical payment for settling that debt. Compare this maintenance order in separation situation to maintenance order under a divorce. You should know that an order here under the SMOO is aimed for immediate needs of the applicant. It is generally limited to a certain period of time. And by its nature, it is maintenance while the parties are married but separated. So it's temporary. It's a temporary arrangement. And hence, that's why the maintenance order here is also temporary in nature. It's limited with a certain period of time. It is also independent from any other reliefs, meaning that you don't have to get a divorce or nullity to get this maintenance. But the maintenance for divorce, you need to petition for divorce first. And most significantly, there is a cap with reasonableness. We will talk about this when we cover finance, but in modern day, in modern law, there is no longer a requirement for reasonable needs for maintenance following a divorce. This is really important. For maintenance and education for a child, similarly, you can have a lump sum or periodical payment. There is also the requirement, the limit of reasonableness. And you also look at the means of both parties to the marriage. I didn't put it in here, But in the same ordinance, under Section 5, subsection 2, there is a further limit on a lump sum order. It is only for the immediate and non-recurring needs of the child. Non-recurring means it can't be for providing for housing, because you continue to live in a place. So you can't have a lump sum, a sum of money for buying a house, because the limit is for the immediate and non-recurring needs of a child. Or a lump sum order can only be made for enabling liabilities that have been incurred and incurred reasonably in maintaining or educating the child before the making of the order. So in other words, there are only two situations where you can have a lump sum order. That is either when you have immediate non-recurring needs for a child, or if you have spent some money in the past for the purpose of maintaining or educating the child, and that lump sum and that expenses is reasonable. That's in Section 5, subsection 2. I didn't put it here. It's very easy to read on your own. Also, in relation to children, in Section 5, subsection 3, the court would have regard to the best interest of the children in making this order relating to the maintenance and education of a child. You can't make a maintenance order beyond the date when the child is already 18. So you can only maintain the child up till he's 18. But then the court has the discretion to extend that period. So the default position is that you can only be maintained until you're 18. But then if, for instance, if you proceed to go to university and then there's reasonable maintenance that is required, then the court can allow the period to be extended, maybe up till the completion of the child's education. This is Section 12 of SMOO for your reference. The last order you can get is a cost order, as long as the cost is reasonable. There are other further limitations that under Section 6, subsection 1, no order shall be made, no SMO can be made if it is proved that the applicant has committed an act of adultery. But there's a condition, provided that the husband or the wife, so the other spouse, has not condoned or connived at, or by his or her willful neglect or misconduct conduced to such act of adultery. So what it means is that if the applicant has done something wrong, then he or she cannot act against the other party who has also done something wrong. It echoes the equitable doctrine of clean hands. It is for fairness, simply. But if the respondent has accepted or allowed or cooperated with the applicant's adultery, then the applicant is not barred from receiving such an order. He or she can still ask for an order. So if I committed an adultery, I can't ask for that order. I can't ask for an order under the SMOO. But if my husband has accepted or allowed or cooperated with my adultery, then I can still ask for an order. Okay? And in subsection 2, you can't have an enforceable SMO well, let's put it the other way. I probably won't just read it. To have an enforceable separation and maintenance order, you would need to move out of the residence. You would have to move out of the residence to prove that you are not residing together. And if a married couple continue to reside together for a period of 3 months after the order is being made, the order will cease to take effect. Because the order is called separation and maintenance order, you have to separate physically. And I think the separation in the context of separation maintenance order is very different from separation in the context of a divorce. In here, the requirement is that you have to move out. But for a divorce, if you want to rely on separation, we will talk about this on Friday. Don't worry about it. I'm just flagging it out. If you rely on separation for divorce, given the limited space, the living space that we have in Hong Kong, it is okay because you can still be deemed to have separated even if you're still living under the same roof. It is still available for you to get a divorce. I've done a case, or I've seen a case, where the parties are still sleeping in the same bed and they still claim separation. But then the client changed representations, so I don't know what happened next. But it's something that I have seen. Here, strictly, you have to move out of residence. So the court has the power to alter, vary, discharge, suspend, or revive after suspension any order made under the SMOO, the ordinance. There's a typo here, I missed an O. The application can be made by the husband or the wife. That's straightforward. And each time when you seek to change the order, whether to vary it or discharge it or to suspend it, you will need to adduce new evidence when you ask for variation discharge. The court can discharge an order if there is proof that the applicant resumes cohabitation with the other party or commits an act of adultery. So if you ask for a Section 5 order, an SMO, but you voluntarily resumes cohabitation with your spouse, or if you commit an act of adultery, then this order, upon proof, will be discharged. The discharge is not automatic. As you will see from the wording of if there is proof, you need evidence. But the order will not be discharged and it will continue to run if the act of adultery is a result of the failure of the respondent to make payments when he is able to make such a payment. That's what Section 7, subsection 4 means. And then you have when order has been discharged because of adultery or resumption of cohabitation, the court can make a new order regarding the custody or maintenance of of the child to continue. And again, in making such an order concerning a child, you have to look at the best interest of the children or the child. Now this enforcement, what is very special about this enforcement is that you can actually attach the income of the respondent if he fails to pay the maintenance without reasonable excuse. This is really rare. I don't recall any other venues where you get to attach a payment to somebody's income. This is actually really onerous. And enforcement, it can be done by way of payment of interest or arrears of maintenance. You can also have a surcharge if a respondent fails repeatedly. Sorry, there's another typo, it's repeatedly fails to make full and punctual payment without reasonable excuse. Okay, that's all the slides I have for today. I think this is the longest lecture I will probably give you. To me, I would prefer to keep it short and concise and to the point. I'll leave you room. I'll leave some room for you to ask questions and have discussions in the forthcoming lectures.